Thank you for joining us. My name is Kimberly Lindy, and I'm the Director of IP Resources, a boutique consultancy in Israel. And we specialize in IP recruitment and professional development. And one of the things that we do is the webinar that we are hosting today. Our flagship annual event is the BPIP, the Best Practices in Intellectual Property Conference, which brings to Israel the best of the best, really the international experts in IP, speaking to Israel, to the IP community, keeping them, and in particular, IP managers and counsels of their companies up to date and apprised of global IP developments and practices. BPIP has been touted as one of the best IP conferences in the world, which was an amazing surprise, but that was said by former USPTO Director Dave Kapos. So I think that when the skies open up, we would welcome any participant from any corner of the world. And I do know that today, not only do we have our Israel audience, we have people from all over the world joining us today, and you are all, of course, extremely welcome. But as we cannot meet in person yet, we are pleased to be able to present through a series of webinars our global experts and faculty who would have presented at the conference. In the near future, we will also be offering online and interactive professional development masterclasses, which will also be taught by global experts and faculty from universities from all over the world. So we're looking forward to providing this excellent service, and stay tuned for more details about that. But before introducing today's program, I would like to thank Kim Fowey Pereira and Crystal, I'm going to say it wrong, Crystal Shafar in Washington, and Zahava Avior in Tel Aviv, and the entire team at Finnegan for all of their help and their expertise in setting up this program. So really a big thank you to them. Now, I would also like to note that we had over 150 people who signed up, and this really shows to us how important the subject is, and I'm really delighted again to welcome everyone here. You will be able to ask questions, okay, during the presentation. If you look at the bottom of your screen, the way to ask the question is through the Q&A. But if you have any technical problems, you can write in the chat, because we've got people at Finnegan who are monitoring all of this, and they are totally set up. So questions and answers, both Darren and Elliot will be able to see, and but the chat if you've got any technical problems. Okay, without any further delays, I'm sorry I've taken so much time, but I would like to present today's expert faculty from Washington, D.C., a little bit outside of Washington, but they will be speaking on drafting patents to survive patent eligibility threats in litigation. Elliot Cook, raise your hand, Elliot, over there, is a familiar face on the Israeli IP scene. He maintains a diverse intellectual property practice, which includes patent litigation, post-grant patent challenges, strategic patent prosecution, and portfolio development, and of course, monetization. Elliot devotes a significant amount of his practice to helping his clients strategically develop patent portfolios that effectively block competitors and build corporate value. And he works closely with clients to ensure that their patents align with and advance their business goals. And this is one of the reasons why he's such an expert on today's topic. Based on his involvement in more than 25 patent litigations, Elliot has significant experience both defending against and asserting patent rights. Darren Jiron, you can see him there. Wow. There's anyway, I just got a message from someone that they're having a problem getting in. So we will deal with all of that. Okay, so Darren, as well spent many a week in Israel, helping Israeli clients focus on building strategically developed patent portfolios, with a special interest in helping high-tech and fast-growing companies craft patent plans to block competitors and build corporate value. Darren works closely with clients to ensure their patents align with and support their business goals. And this is also, for Israeli companies, the key. And of course, these guys know it. Darren has more than a decade of litigation experience and has represented clients in all phases of patent litigation before numerous U.S. district courts and the U.S. International Trade Commission, et cetera, et cetera, et cetera. Really, they're both really amazing, and they're partners at Finnegan, and which is of course one of the world's largest IP firms and one of the go-to sources for Israeli companies when it comes to IP. So they have experience helping Israeli companies to navigate IP disputes and patent infringement, and to maximize, of course, the value of their patent portfolios. And in other words, as I said, we are extremely, extremely, extremely lucky to have both Elliot and Darren and their combined expertise and giving us the significant webinar today. So without further ado, I turn it over to you guys, and I will help these people try and get in because they are being told that they can't. So we want as many people as possible to be able to hear. So I will go off. I'm going to take away my picture and to mute. Again, remember the Q&A is at the bottom, and if you've got technical problems, the chat. Have fun.
Okay, thank you very much, Kim. Yeah, we are, Elliot and I are both very happy to be here today. Kim puts a great program on every year in Tel Aviv and does a great service to the IP community in Israel, and we're really happy to be a part of it. And really, even despite the challenges this year is no exception. I think Kim has done a really good job of pressing forward and putting together some great content and really helping the entire community get together and share some great ideas. Of course, we wish that we were in Tel Aviv to see everybody, but this platform seems to work out pretty well, and so we'll give it a go. In fact, I think over the past several months using this platform a lot more, I've been able to see a lot of people even more than I used to, and Elliot is even one of the examples. I sit down the hall from him at work, but I tend to call him on the phone, and this way with the video, I've been able to see him quite a bit more. So that's it's not necessarily a bad thing. So Elliot, let's throw up the agenda. So for today, we are going to talk, as Kim said, about how to draft patent applications, focusing on the specification and the claims in order to survive patent eligibility challenges during litigation. So no patent eligibility inquiry can really start without at least a brief review of Alice and Mayo, which are the current tests applied for patent eligibility in the U.S. right now. We'll move on to a couple of interesting topics: early motions and factual considerations that arise in litigation with respect to patent eligibility challenges. After each section, what we're going to try to do is get to some tips and best practices based upon the section we're talking about. But at the end, we'll also include a few drafting examples to try to put in place some best practice tips and practices in some practical claims that we can look at and specifications. And finally, we'll wrap it up with a Q&A session. But as Kim said, we've got access to the questions, and we'll do our best as we go along to answer those. And if there's any that we don't get to, we will work to follow up with you guys after the webinar. Next, okay, so the U.S. Supreme Court has really set forth what is the real test for patent eligibility at the moment. It started with a Mayo decision. It was extended in the Alice decision, and effectively what it is, and many of you are familiar with this, is if we get over the very first threshold question of patent eligibility, which is the claim to one of the statutory categories like process, machine, manufacture, composition of matter, then we can go on to determine, we can apply, if we need to, the Alice two-part test. And the first part of the test is whether or not the claim is directed to one of these judicial exceptions, like an abstract idea, a law of nature, or natural phenomenon. If it is, then the claim goes to the second prong. And the second prong is, well, I should say, if it's not directed to one of the judicial exceptions, it's patent eligible or deemed patent eligible. If it is found to be directed to one of the laws of nature or to other judicial exceptions, then the second prong of the Alice test is applied, and that's whether the claim recites additional elements that amount to significantly more than the judicial exception. The directed to language here really is the key, and it really sets the groundwork, which we'll talk about in a moment, for the patent eligible decisions that have been coming out of the courts more recently. Next slide, Elliot. And one of those examples is the Enfish case that came out of the Federal Circuit. And really, this case, I would say, if you have a chance to look at just one case that might be the archetypal patent eligibility discussion to really advise on how we should shape our patent claims, this is the one. It's one that I think is really exciting and really sets the groundwork for some really practical examples going forward of how we can structure our patent applications to better improve the chances for being found, our claims being found patent eligible. One thing that the Enfish court determined was that they really focused on, like I said, the directed to language of that first prong of the Alice test as being really important, because they found that, you know, they were looking at the Alice test and its application and said, you know, if there are, the Supreme Court had already recognized that one of the difficulties, which probably many of you have faced, is, you know, if every claim at its heart has some abstract idea associated with it. So if we take that as a premise, then does that mean that we have to apply the Alice test to every claim to determine first, does it have an abstract idea in it? And if the answer is yes, then we go on to the second prong to determine if there's something more. Well, that's somewhat problematic in that, you know, even the Supreme Court recognized that that's very dangerous because it has the possibility of swallowing up patent law as a whole, because you've now put in place a test that almost every computer-oriented claim will have to go through in order to get out of this Alice two-prong test to show patent eligibility. So as a result, what the Enfish court was really looking at was, you know, if there are some computer claims that can be found to be directed to a judicial exception like an abstract idea, they reasoned that must mean that there must be other computer-related claims that are not directed to an abstract idea. And they went through in their minds about what are some examples of computer-related claims, for example, that should not be found to be directed to abstract ideas. And one example, which was actually suggested in the Alice case, was that a technological improvement can effectively short-circuit this analysis. And the Enfish court really locked in on that and said, you know, if the claim describes a technical improvement and embodies that technical improvement somehow, then it's effectively a short circuit for the Alice test. We're not even going to go there. We're going to say, because it's directed to a technical improvement, we don't need to apply the Alice test because it's not one that's directed to an abstract idea. And then we can move on from there. Now, the Enfish case was directed to a relational database that was found to improve the way data was stored, access to video and text, et cetera. The important thing here was that the new features, which really are part of what an innovation means, the new features that this relational database offered, and perhaps the problems that were solved in order to be able to provide those features were embodied in the claims. And so therefore the court found the claims are directed to this innovation, this improvement, this technological improvement, and therefore did not get to the Alice test at all. So next slide. So really, what we're showing here is the original Alice two-part test. First, is it directed to a judicial exception? Second, is there an inventive concept? Those are the hurdles you have to get through to find patent eligibility. However, Enfish adds another layer to this. So what Enfish does is really what I think of as a pre-inquiry, is if we can show that our claim—
Darren, sorry.
Yes.
For whatever reason, there were about 20 or 30 people who could not get on until now.
Okay.
They're all on now, but if there's anything that you want to just summarize of what they missed, or we can go back, or we can send them slides, but there was some problem in the link. It's now been solved. Just, I needed to let you know.
Okay, thank you, Kim.
Okay.
Probably the best way to proceed is just to say we've just started talking about the Alice two-part test. It's difficult to apply. Enfish is a Federal Circuit decision, which is, I think, the framework for everything eligible in the computer-related area going forward. And what Enfish does is provides this preliminary layer that if you can show that your claim is directed to a technological improvement, really what a patent application or a patent is all about. It's about innovation and what features have we contributed to the technology space. If the claims embody those technological improvements, then the courts have something to point to and say the claims are directed to this improvement, therefore they're not directed to the judicial exception that Alice was concerned about, and we don't have to even apply the two-part test. So next slide. So as you can tell from the highlighting here, I think this is probably an important takeaway from today's presentation. And that is that technical improvements are critical, especially in the electrical area. And I say that because since the Alice decision, there's been about 120 or so Federal Circuit decisions that have applied the Alice framework, the patent eligibility considerations and tests. There's only been about 23 of those 120 where there have been patent eligible claims found, which isn't a great track record, but of those 23, 19 of those have been in the electrical space, the computer space. And what's really interesting here is that of those 19 that have been found patent eligible in the electrical space, 15 of them have directly applied the Enfish test, which is if I can show a technical improvement in the claims, then we're not even going to go to the Alice test, Alice two-part test, and use that as the basis for finding patent eligibility. And the remaining 4, those also applied the very same logic, which is there a presence of a technological improvement? It's just that they went through the Alice test and found that the presence of that technological improvement showed patent eligibility in the second prong of the test. Nevertheless, it's the technical improvements, whether you go through the Alice test or not, they're going to lay the framework for patent eligibility in the electrical space going forward. Next.
Somebody's not in mute.
Yeah, if you can mute your speakers, that'd be great. And Elliot, if you can advance the slide. So based upon that first introduction, effectively, what are some drafting tips that we can take away from the Enfish guidance that the courts provided? Well, first of all, it may be sort of a Captain Obvious statement, but we want to model our claims off of those that are held eligible by the courts. That's really one of the safest things we can do. Second, since we had this highlighted guidance, which the technological improvements are really important, we want to capture aspects of the technical improvement in the claims. Now, that doesn't mean that the claims have to lay out the entire technical solution of a particular feature or functionality or solution to a problem. But what it has to do is it has to have some kind of a hook or something that it goes to the particular improvement that patent application is about. So some examples of what we can include. We can include effectively we can describe in the claim a new feature or a new function that's provided by our advancement, one that didn't exist before. We can also go even a step further and describe in the claim how the new feature or function is generated. Especially in that while that's a narrowing, it narrows the claim a bit, but that can be important, especially if that solution to a problem is one that we think that competitors will have to include in their own systems in order to generate the same features and functions. Next slide. So this is the Packet Intelligent versus NetScout case, and it was one that was very recent. In fact, just in the last couple of weeks, and it provides an example of what we mean by including effectively a technical solution to a problem in the claim, or referring to what the solution is. There's a lot of words here in the claim, but effectively the problem that the patent applicant faced was that there was a way to monitor communications between a client and a server, for example, by monitoring data packet flow. But there was the direct connection between the client and server is referred to connection flow monitoring, but there's an interest in understanding something more broad, something called the conversational flow monitoring, that could include multiple connection flows, the direct connections, but also it could include other connections as well. And so there was an interest in monitoring not only our direct connections, but those that might be related to multiple connections, for example, and it required another layer of monitoring. And what this claim is about is it's configured to extract portions of accepted packets and output a parser record containing the selected portions. But what it does is it looks up whether a particular packet that's coming in has a flow entry already in the system. And if it does, then it marks it as part of an existing flow. And if it's something that it doesn't recognize, it recognizes it's a new flow and establishes a new record. And this is it's a way that the system can track as a whole these conversational flows versus just direct connectional flow monitoring. So, you can take a look at the claim on your own, but this is an example of including the technical feature that the system is providing is the ability to monitor conversational flow as opposed to prior art systems that only monitored connection flow. And the claim talks about what it is that we have to establish in order to allow us to monitor the conversational flow. And that's that process for bringing in a data packet, marking it whether it's recognized or not. And if it's not, you make a new one. If it is, you mark it as joined with an already existing flow. So it's an example of including how the problem is solved in the claim. Next. The Ericsson versus TCL case is also a recent case that came out of the Federal Circuit. And one of the rules and guidance that we can take away from this is that technical jargon is not a substitute for incorporating a technical solution in the claim. So this claim is actually about providing software updates from a certain platform, software updates. And what you notice here are there terms in the claims like access controller, interception module, and decision entity that sound technical and they sound like they must have important jobs. But when you look at the jobs, there are things like they're just controlling access to the software service component, or receiving a request, or determining if the request should be granted. And then the where-in clause says if you determine that it should be granted, you grant it. So it's not, one thing that's really important to take away from this is we can all probably imagine that there are many technical aspects of this system that would support patent eligible claims. But this is an example of claiming at a very high level of generality such that it opens the claims up to being vulnerable to patent ineligible challenges, because we're not really reciting anything here that talks about the technical feature that we've added beyond what others systems have done, and we've not talked about how anything's accomplished. We've just claimed it at a very high level of generality. Next slide, Elliot. So the Ericsson case, I would say, is an example of what not to do. It's an example of how to make eligible or potentially eligible technology patent ineligible. We can all imagine that in order to receive a request for a software update and then determine whether you want to provide the request, there are many things that would have to be involved, like determining if the requester is able to receive it, or somehow figuring out the identity, and many, many other technological aspects. Any of these things could have been described in the application and used in the claims to make an eligible claim, but rather this particular drafter left it at a very high level of generality and left it open to what the arguments that the patent owner made here was that, yeah, wait, there's this very detailed layered architecture that I show in my figures. But the court found that there's nothing about this layered architecture, if it's novel, that's found in the claims. The district court even reasoned before it got to the federal circuit that there's technological improvements described in this application to address the problem that exists, which is that there's limited memory and resources on mobile phones, and that's what contributes to the difficulty in getting these software updates. Again, none of that particular problem, nothing related to that particular problem, or even more importantly, how that problem is solved, has made it into the claims of this particular example. So the takeaway here is that, again, tell the story of the technical improvement, the new features that we've established in the technology, the advancements we've made, and figure out a way to incorporate those back into the claims in at least some part. And we'll go through a couple of more concrete examples later on. So Elliot, I will turn it over to you now at this point.
Great, thanks, Darren. And I'd like to echo what Darren said at the outset too. It's good to see everybody virtually. We do wish we could be with everybody in person. And thanks again to Kim for putting on these great seminars year after year. These really are special. So thank you, and I hope everybody's in good health. Let's talk about early motions. Let's talk about how these cases actually come up in court, because what happens in court matters. What happens in court instructs us how we should be drafting patent applications and drafting claims. So these are some of the lessons learned, and we'll try to be as specific as we can about these to give people practical guidance. And one of the things that we'll talk about is controlling the narrative. What is the narrative? The narrative is the story of the invention. It is, what is the technology that you've invented? Why is it new and why is it better? And these are things that you don't want to wait until the jury trial at the end of the day to tell the audience. You want to have some of this in your patent application, and we'll talk about specifically why. We want to emphasize the practical applications and concrete examples of the invention. Don't describe everything in the abstract. Provide a few use cases. Provide a few specific examples of the invention being used. Avoid patent profanity. And this changes year to year, but some of the current patent profanity that we do not want to see in patent applications, if we're the patent owner, are terms like routine, well understood, and conventional. These are some of the terms that, if you use them the wrong way, they can undermine your invention, especially in terms of early motions. And avoid mental step language. Avoid manual steps, mental steps. Avoid a claim that can be done entirely in the human mind, or where computing equipment is merely just an afterthought. Integrate the invention with the technology, and do that in the spec and do that in the claims. We'll talk about these. So here's an example. This was a case, the Uniloc versus LG case, where Uniloc was suing LG, and basically the technology here, it's pretty easy to understand. It's really, you have two different things. You have a base station, and it's communicating with some other device. Maybe it's a mouse, maybe it's a keyboard, but it involves wireless communications. And here the applicant did something good in their specification. What they did is they described the technological improvement that's going on. They said, in contrast to prior techniques that can take tens of seconds to establish a connection between your wireless keyboard or mouse and your computer, ours is much faster. So we have here in the specification a reduction of latency experienced by parked secondary stations. So they're speeding up the process of connecting your keyboard to your computer, and they're saying this is a technological improvement. It's right there in the specification. It's something the court can see and give weight to when the court is addressing an early motion. And so here what happened was this patent was asserted against LG. LG filed an early motion, a Rule 12b6 motion to dismiss the complaint. The district court agreed. The district court granted the motion, but when we got to appeal, the federal circuit reversed. So although the district court found that the claims were ineligible, the federal circuit, and Judge Moore specifically, found that the claims were directed to a technological improvement. And to Darren's comments earlier about the Enfish case, that's basically what happened in this case. That was the analysis. The court was looking at the technological improvement in the specification, and we've highlighted that here. And really what the technological improvement was speeding up this connection process of connecting your wireless keyboard to your computer. Because that was made faster by this invention, the invention was technological. So we have the thumbs up under Alice step 1. We don't even need to get to Alice step 2. The claim is eligible, the federal circuit found. And one really important takeaway from this case too that clarifies what the standards are is there was an argument on appeal, and the argument on appeal was basically a technological improvement doesn't count. We shouldn't give it any weight at all unless it's in the claim. And if we go back to the claim here, claim 2 was the claim being addressed. It's a very broad claim. The claim doesn't say, and here's the improvement, right? The claim doesn't say, here's the problem and here's the problem being solved. Instead, the claim lays out a solution, but without really saying that this makes the process faster. The claim itself doesn't say that we're reducing latency. The Federal Circuit said that doesn't matter. And this is a very important case in that regard. The Federal Circuit says as long as there's a technological problem being solved, and that's clear from the specification, and the claim embodies the solution, the claim doesn't need to say, we're also solving the problem. It doesn't need to explicitly say that. So a very important case in that regard, and also very instructive about how to draft patent applications. And here's the opposite. Here's a case, the Ubisoft case, where the invention did not pass the 101 hurdle. And basically what this invention was it was a way to teach people to play guitar. Musician had a patent covering this, and Ubisoft is a owner of a lot of game technology. And basically this was a technique of presenting fingering notations that the user could see. They could play the notations on their guitar. Whatever the guitar player plays would be picked up, assessed. There could be a different changing of the difficulty level of the notation patterns being presented to the user. And then at the end, we would generate a little game, a mini game for the user, basically as a practice, a way to get them to get better at guitar. And as you may be suspecting from the way this claim is set up here, this is basically reading like a live guitar lesson in person. This is almost like the process you would go through if you're sitting down in a music studio with your instructor, and your instructor is telling you how to play guitar. These are some of the same steps the instructor would go through. And of course, in this case, the claim was found to be abstract, and it did not involve substantially more than that abstract idea, so it was not found to be patent eligible. Now, to Darren's earlier point, it didn't have to be that way. Darren is absolutely right when he said that you can take an invention and you can make it ineligible if you claim it the wrong way or you describe it the wrong way in the spec. And I don't want to sit here and second guess these applicants and what they did in this spec, but let's remove ourselves from this patent a little bit and talk about an invention relating to teaching guitar. You can imagine ways to make that more eligible. You can imagine ways maybe to integrate AI techniques to learn what the user is doing, maybe to match what they're doing on their guitar versus a library of known techniques or known mistakes that you could correct. There are certainly ways to make this more practical in the application. Maybe you can involve sensors somehow on the guitar itself. Here, the computing equipment was generic. The computing equipment did not really address any technological problem. This was really just using ordinary computer equipment to perform the manual task of an instructor teaching guitar. That's really all it was. So again, not to criticize this applicant or these claims, but you can imagine how an application could be better drafted to cover technological approaches to teaching guitar, not merely mental steps that are captured by computing equipment. So those are a few early motion examples. One of the main developments that we saw in the last couple of years relating to early motions under 101 is the Berkheimer case. And I'm guessing that a lot of folks on the line know what happened to Berkheimer. And I won't spend too much time talking about the facts of Berkheimer itself. But basically in the Berkheimer case, this was a case where the district court found the claims invalid under 101 at summary judgment. And the Federal Circuit reversed. This was again Judge Moore at the Federal Circuit who wrote the opinion. And basically what Judge Moore said was what a lot of people were suspecting in terms of 101. And that is, if you have underlying factual inquiries that go into the step 2 part of Alice, is there anything inventive about the claims? Shouldn't that involve factual considerations? And if the answer is yes, there are factual considerations, the consequence of that is shouldn't the jury get to decide those? Or at least shouldn't the judge have an opportunity, if the parties agree, to have the judge decide those factual questions? And the reason that matters in an early motion, whether it's a 12b6 motion or a 12c motion, is if the judge is dealing with one of those early motions, the judge is required by rule to treat any well-pled facts as true. And if the patent owner has in their complaint a certain fact about what is novel, inventive, or not well understood in the field, If that's a well-pled fact, under Berkheimer, the judge needs to give that weight. It needs to assume it's true, because the judge's job at one of these early motions is not to prejudge the case. It's just to rule on the pleadings, basically, assuming the facts as pled are true. So this case was very consequential. It led to, as we'll talk about, fewer early motions and less success for early motions under 101. So really what we have in view of Berkheimer is we have our Alice step 1, which is more or less unchanged. We're looking at whether the invention is directed to an abstract idea. Under Alice step 2, there can be, but not always are, factual considerations. And the way that these factual considerations come up most naturally is if the patent itself lays out what the technological problem is and what the solution is to it in technological terms. If that is in the patent, then therefore that can be in the complaint too. And the patent owner can file a complaint in court saying, here's my patent, here's the infringement, and also here are certain facts about why my patent is not conventional. And so what happened in this case was the certain claims, but not all claims in the patent were found to have been improvidently determined to be invalid. There was a remand back to the district court for that to be considered. And this case is still going on, by the way. There was a request for cert by the Supreme Court, which was denied, but this is back down at the district court level to allow the parties more time to brief specifically what was routine and conventional in this field as a factual matter. And so the bottom line here, we can spin through this slide quickly, is that even though Berkheimer dealt with summary judgment and said that factual considerations need to be considered, that same ruling has been applied to early motions, 12b6 motions and 12c motions. And as we talked about for those early motions, if there are facts in dispute, the judge cannot rule on the merits of the 101 issue if those facts would be meaningful in the 101 analysis. This is pretty striking. This is the early impact of Berkheimer. So if we look above the dividing line here on the right, we see Rule 12. This is really saying that pre-Berkheimer, there were first a lot more types of these early 101 motions under Rule 12. After Berkheimer, a lot fewer motions overall. So the number of motions themselves has gone down. In addition to that, the success of those motions has gone down as well. It's almost 50-50 now, post-Berkheimer, in terms of these early motions. And of course, what's happening here is attorneys read Berkheimer, they read the cases coming after Berkheimer, and they self-select the cases where it makes sense to file a 101 motion and the cases where it doesn't. That's part of the dynamic we're seeing. And of course, also it's summary judgment. We're seeing the same dynamics, a lower success rate and also fewer motions being filed under 101. So that's the impact of Berkheimer. This case to me is fascinating. This case is basically saying if you consider Berkheimer and it's teaching that if there are factual considerations, those need to be decided, and you can't rule against the patent owner if they've pled pled facts regarding 101 and what's inventive. This case, PPS data, takes that reasoning to the extreme. And this is a recent case. This is the first case where a jury has decided the issue of whether something passes muster under 101. So what happened in this case was this was a technology directed to electronic check deposit processing. You can scan a check and you can deposit it electronically. As the patent owner said in their patent, this was the alternative to having to go to the bank and do everything manually. Basically what happened is Judge Gilstrap in this case in the Eastern District of Texas said that yes, these claims are directed to an abstract idea, and this was its summary judgment, but he wasn't able to rule against the patent owner because there were 3 areas where there were facts in dispute. So he said, I'm not going to rule on those areas of facts that are in dispute because this is summary judgment. That's an issue that needs to be decided by the jury. And that's what happened in this case. The jury was asked to decide for the first time ever how to deal with these 3 facts in dispute relating to patent eligibility. And here, the jury in the Eastern District of Texas found the claims ineligible. The jury found the claims invalid. And so basically what these claims were directed to was the process of remote capture of check data using the MICR codes in checks, for example, and looking at the errors potentially and correcting errors on the checks. What the specification had in this case was not bad. The specification had some references to not needing to go into a physical bank, being able to cash checks remotely. So the specification had a few hooks. And again, this is why the case was able to get beyond summary judgment. The patent owner had enough in the specification to get past summary judgment and get to trial. But in this case, that wasn't enough. That wasn't enough for the patent owner to win the case, because the jury eventually decided that these claims were ineligible. And I think the teaching here in terms of what to include in the specification, for applicants, is really when you say something in the specification about what the technological problem is and what the solution is, you're doing a good thing. You need to do that. You're also providing a target for the other side to shoot against later in the case. They know what the technological problem is, and they know what the technological solution is that you're asserting. And that's exactly what happened in this case. In the jury trial, the defendant came out and they said, okay, if this is what you're alleging to be the technological problem and solution, that was known and done in the field. People were caching, doing scanning of these checks before. That wasn't new. It was commonplace to scan the MICR codes. That wasn't new either. All of the technology was routine and conventional. And so really, the statements that the applicant included in the specification were good. It just gave the other side a roadmap about what to challenge at the jury trial. And isn't this fascinating? This is how the jury decided the case. This is the actual jury verdict form. In addition to finding non-infringement, the jury here found that the claims are only directed to well-understood routine and conventional technology as of 2000. The first case that did this, very, very fascinating. I've had other cases, including with Jeff Berkowitz, who's on the line now, where the 101 issue was basically decided by the judge after trial. But again, this is a groundbreaking case in this regard, being handled by the jury. So a few takeaways. In terms of what you put in the specification, avoid saying that certain features are routine and conventional. You don't need to do that. It's not necessary to call out features as being routine and conventional. Even if certain aspects of them may be routine and conventional, you don't need to help the other side and make their case for them. And maybe what you're saying is a little too broad anyway. Maybe you should be careful about calling something generally routine or conventional. Yes, include the technological problem, and yes, include the solution to it. And when you're describing the solution, include a good amount of technical detail too, to really show that you're dealing with a technology, and the inventors have come up with a specific how in terms of how they're dealing with it. Also, a takeaway from Berkheimer, dependent claims matter. In that case, the independent claim was not deemed to be representative of certain dependent claims, and therefore the dependent claims got their own individual analysis. Very important. Make your dependent claims do work. And so now we'll get into some drafting examples. And these are coming in large part from the PTO's January 2019 guidance to practitioners. The PTO has unveiled additional examples and guidelines since then, but these are a few that Darren and I thought were good to instruct the audience here about what to do and what not to do in patent applications. So this first one involved NetFlow. And NetFlow is basically, it's a technology invented and developed by Cisco in 1996 that measures the volume of data traffic going in and out of a switch, for example, a network switch. And here, the problem is there's so much data. If you're always tracking all of the data going in and out of a switch, you're going to be overwhelmed with data. And so here the invention was basically, let's only record that data when there's an event, when there's an anomaly. Kind of like a security camera that only records when there's motion, not all the time. Same idea. And so here, there's two different versions of the claim. The version of the claim on the left, the Patent Office tells us is acceptable. It's not ineligible. The claim on the right is ineligible. It's not going to pass muster at the Patent Office. So what does the Patent Office tell us about these claims? What is the reason these may or may not pass muster? Well, for the claim on the left, the Patent Office says that it is specific about the network delay, the packet loss, or the jitter. It's not simply talking about network traffic generally. It's looking for these specific kind of things. But what mattered the most was the last step in the claim. So once we've done our comparison to look at the network traffic in our predefined threshold, we will collect additional traffic data, and we'll look at whether that's greater than the threshold, which is based on this NetFlow protocol data. So it's not simply looking at data, it's looking at data and then doing something. It's not simply collecting data and having an output. It's more of the how, about how the invention is being implemented, how the problem is being solved. And, you know, more than anything else, that's really one of the main takeaways that Darren and I hope to pass along. The how the problem is being solved is of the utmost importance. That's a clear teaching from the case law. And so we have that with the claim on the left. We don't have it with the claim on the right. The claim on the right is more like the Alstom case, the electric power case from a few years ago at the Federal Circuit. This is just looking at data and performing a comparison. And if all your claim is doing is looking at data, having a comparison happen, and maybe having a visual output, that's not enough. That's going to be considered an abstract idea without substantially more. There needs to be a how. There needs to be a problem being solved in the claim. Okay, and back to Darren.
Okay, thanks, Elliot. You know, when Elliot was talking a bit ago, a couple slides ago, about the words well-known, routine, and conventional, you know, it kind of jogged in my memory. Really, as Elliot mentioned, those terms are patent profanity, and we would recommend just not including them anywhere in the application, because it gives the challenger effectively a hook to go after the eligibility of the claims and find patent ineligibility, even where the situation may warrant or support claims that are eligible. And the thing that I was thinking of was, I think there was a recent case about a garage door, a remote control garage door opener, and even the claims were very technical. They should never have been really considered for a patent ineligibility inquiry at all. But the problem was, in the specification, they had terms like routine or well-known or conventional that they attached to just parts of the remote control, just certain aspects of the remote control. And a lot of times there's a tendency to say, you know, here's this combination of elements. Here's one of the new things we've added to provide the new feature of this remote control garage door opener. And they say, and then they go, sometimes the applicant goes on to say, and you know, you can use any alternatives for this things, you know, for this particular feature or this particular aspect. Many of these are well known in the art, or you know, routinely the skilled artisan understands that these things can be used. And the problem there is that when those words appear, they're very important buzzwords for finding patent ineligibility. But really, I think, as Elliot mentioned, what is important here is not so much if it's the one particular feature that's well known or routine. Our invention really is a combination of elements that haven't been put together before, and each one of those elements could be well known or routine in their own right, or used out in the prior art in different ways. But when put together, they can, in combination, they can be something completely new and unique and provide a new functionality that didn't exist before. So the danger with describing those types of combinations of elements is you really give the court something to latch onto and find claims that really may be directed to technology that should otherwise be clearly eligible. It raises these issues of patent ineligibility. So from a drafting perspective, how to keep that issue out of litigation, it starts with avoiding those three words. So with respect to this example, it's one that I think it's really instructive, and I really like it because we can all relate to it and it's easy to understand. But the problem here is that, as we all know, we have smartphones and they have icons on them. And if you're like me, you acquire lots of applications and then therefore lots of icons, and you never want to take them away because you never know when you're going to need them. However, because I've now got 100 icons on my screen, it's hard to find some of the ones, especially those that I don't use that often, or the ones that I do use often I want to have quick access to, and I have to swipe 5 times to get to the next page. And what this innovation is about, the technical improvement, the improvement what didn't exist before, is the ability to monitor which applications and which icons are interacted the most by the user, track that, and use that information to automatically arrange the icons in a way that the most used are put on the first screen, for example, and subsequently less used icons are put on subsequent screens. Now there are different ways to do this. One is by monitoring the amount of use. You can also have a user that manually enters icons and puts them in a ranking list. The point is that there are different ways to get that information about how much the user interacts with a particular icon. And so we'll look at a couple of examples here of claims that are directed to this particular technical innovation. And we'll look at the next slide, Elliot. What we've given here are 3 examples of claims that I would say fall into a spectrum of, on the left side of our screen is a claim that's more likely than not to be found patent ineligible. And as we progress across the screen to claims that are more and more likely to be found patent eligible. So remembering our technical improvement, which was the feature of automatically arranging the icons on the screen so that we have easier access to that. Let's take a look at the first example on the left. So here we've got a method of ranking icons, and it says determining by a processor the amount of use of each icon over a predetermined period of time, and then taking that information to rank the icons by the processor based on the determined amount of use. Now, there's a couple issues here. The first one is that including the words by a processor in some cases can add technical aspects to claims, but the courts have found that just including a generic processor on its own doesn't rise to the level of taking an ineligible claim and making it eligible. The bigger issue here, in line with the topics we've been talking about today, is whether or not this claim example embodies or somehow relates to that technological improvement that we would have described in the specification, which is once I have the information about how often the icons are used, how do I automatically arrange those on the screen to make it a nice feature for the consumer? And the claim stops short of doing that. Basically, what we have here is we determine the amount of use, and then we just rank the icons. So it stops at perhaps creating an internal database of which icons are used the most and which are used the least. But we don't actually take it the next step and do anything with it. And importantly, we haven't taken the next step to embody what we're describing in the specification as a technical improvement, the innovation, the new feature that we're able to incorporate into these types of devices. On the other hand, if we look at the middle example, there are a couple of additions that likely render this claim a better candidate for patent eligibility finding. And to me, the most important one is the last element, where we talk about, once we have the determination of the amount of use of the icons, what we do is we automatically move the most used icons to a partition on the GUI closest to the start icon of the computer system, and that's based upon the determined amount of use. So here, what we're doing is we're not necessarily describing how or a very particular way of determining the use or how the movement is taking place, but we are referring back to the innovation that would be described in the specification. And the main thing here, the main new feature that we're offering as our advancement to this particular technology is that we'll have the ability on a GUI to automatically move these icons. So that's, I think this claim really offers some guidance in sort of a first level of incorporating our technical improvement into the claims to render them patent eligible. The third example, all the way to the right, is one that I would consider maybe even a more safe approach, where we take it effectively a step further. So not only do we have the same last element, which is the automatic movement, but we go and describe, we give a way that we're able to determine the amount of use, a specific way by using a processor that tracks how much memory has been allocated to each application. And that's a specific way to actually, it might be the most efficient or the most accurate way to track use of the icons. And in that way, give us even better information for being able to automatically move the correct icons to the appropriate spots. So here we have not only the hook to the automatic moving, but we have also a description of how the underlying determination of the amount of use is made. And so, again, likely the claims in the middle on the right would be found to be patent eligible, the one on the left not, but I think it's really can be placed on a spectrum, and you can probably imagine additional claims that might fall within the spaces here to kind of create the entire spectrum. So hopefully that's useful. I believe that our now is next slide, Elliot, I think is our question. And yeah, so we can now take some questions and answers from the audience. And I see that we have a question here. It says, how do you deal with business and money related terms in claims directed to fintech applications, such as methods of calculating risk scores, payment applications, bank transfer authorization methods, and the like? So since I did the hard work of reading that, Elliot, do you want to take a stab at answering it?
I think the hard work is in answering it, actually. That is a question. Look, it's a really good question, and we can provide some answers to it. The most important thing is that the Patent Office and the courts have an unspoken, unwritten bias against financial inventions. Not everyone talks about it, but it's the truth. And if your invention is financial in nature, you're going to have an uphill battle, both at the Patent Office and at the courts. That said, it's not an insurmountable hurdle. We've certainly obtained lots of patents for our financial clients. It depends on the technology. There are different ways to do it. Tying it to something physical is helpful if there's something physical. Maybe it's a payment card, maybe it's a smartphone, depending on the technology. Maybe it's an IoT device. Connecting it to the real world and making it physical is helpful. Removing the financial elements themselves from the claims is also helpful. Take the dollars out of the claim, take the payment out of the claim. If the invention itself is a payment technique, try to minimize those things and really orient the claim in terms of what type of technological problem is being solved. And usually there is one. Usually there's maybe a problem that's being solved in terms of performance, security, efficiency, speed, reducing latency. These are real solutions that you can argue are technical in nature if the invention is specific enough and tied to physical components. So the short answer is take as many financial elements out of the claim as you can and try to dress up the claim as a technical claim. In addition, try to get out of the bad art units of the Patent Office. This is something we always try to do. Some inventions allow you to do it and others don't, but try to get out of 3600, which is one of the worst places to be at the Patent Office. So, have a title that doesn't sound technical, that doesn't sound financial. Have an abstract that doesn't sound financial as well. And if you really need to include some financial features in your application, include them in the specification, but don't give them prominence in the figures or in your summary, your abstract, or your title. So those would be my tips.
Yeah, I agree 100% with everything Elliot said. Get rid of the financials. This is one of the situations where there may be many new features that may be related to a financial or have applications in financial areas or technology, but they could be described in ways where that's just an example for, and there may be other areas where we might be able to apply the certain technological improvement or feature in other types of systems. And that way it can do what Elliot says, is try to get out of the business method art unit at the PTO 3600, and and it also gives you a way to downplay the direct relationship between the claims and the described technology to financial systems only. I would also certainly take the advice to really try to answer the questions that the Enfish case and many others have asked, which is what's the new, is there an innovation here? What's the new innovation we're offering, the new feature, the new level of security we're able to offer, the new level of communication or transaction or organization, sort of like a relational database in the Enfish case that we're able to offer. And despite having those being related to the financial area, isolate those features and find a way to identify those features in the claims, and then also consider the next level. How are those features implemented, and consider whether there's a particular way of implementation of those security features or the transaction facilitation or database management that that competitors will actually have to have, because we can narrow our claims down to those features and be confident that when competitors come along behind us, that even though our claims are narrower, still has a good opportunity to read on the competitor activities.
We're at 5 o'clock. Well, we've got 5 more questions. Wait a second. Let's take a look over there. Do you want to take a look and see whether do you guys want to take a look at the questions and see if there's anything that you want to?
Yeah, I mean,
You
one
can.
of the questions is, can you explain again how the use of well-known language was used against a patent owner? That was, I bet you Jeff, maybe Elliot remembers the name of the case. I can't remember it right off the top of my head, but nevertheless, it was a remote control for opening a garage door opener. And what happened there was the patent owner had described basically a lot of aspects of the remote control as being things that were off-the-shelf components, and said, but we added to it this particular feature that allows it to provide this new functionality. And they said when the feature that they added was something that was a well-known feature from somewhere else, that they incorporated into the remote control, and the court used that as a hook to say, well, all they've added, they admit that really all they've added is this one piece, and they've labeled it as well-known or conventional. So we're going to say that and here's the real problem. This wouldn't have been an issue had the claim not been claimed at least some high level of generality to open it up to this inquiry. And because that inquiry was open, that word well-known or conventional was found in the specification as describing what appeared to be their main contribution. And they found that well, if they're describing it as well-known, that means that it can't add significantly more to pass the second prong of the Alice test, and therefore it's not eligible. But I don't think that the patent owner meant that feature was well-known or routine in the new combination. I think they might have meant in a different context, and that's the real danger.
I just want to say, I mean, we said 4 to 5, but we can certainly go from 4 to 5:30 if the people are staying on and they're asking the questions, and if that extra half hour is okay with you, then we or 15 minutes or 20 minutes. It really depends on the two of you. Israelis, we like to ask a lot of questions.
I see a good question here, Kim. Maybe I'll answer this one about Jepson style claiming. This is a really interesting one, a really creative question. The question is, wouldn't a good old Jepson claim style of wherein the improvement comprises guarantee the claim passes muster? That's a really interesting idea. It reminds me a little bit of the notion that maybe means plus function claiming can also be a technique to make a claim more specific and structural and get around 101. In terms of the Jepson style, I think it would certainly highlight what the improvement is. That's basically what you're saying. I don't think it would guarantee that the claim is going to pass muster. You can imagine a situation where the claim says the improvement comprises X, but the specification is poorly drafted, and the specification says, well, X is well known in the art. This has been out there for years. It's commonplace. Or maybe words to that effect, but not that blunt. Bottom line is, I think it may help highlight the problem. It's better in the spec to do that than it is in the claims, I think. And it's not a guarantee. It may be helpful, but I don't think I'd recommend it. Any different thoughts on that one, Darren?
No, I agree with that totally. I was thinking of the example, one of the examples that we talked about earlier, where there was the Jargon, the Jargon case, where you get to the end and it says, if you determine that access should be granted, you go ahead and grant it. And it, if we used I can imagine a situation where it said, wherein the improvement is that using the computer evaluator, we determine whether or not access should be granted, and if so, grant it. And one, like Elliot says, yes, it signals what we want someone to consider might be the technological improvement in the claim. But the danger is what if it doesn't? I mean, what if it's something that the patent challenger can easily point to as in the prior art? And second is that it may not offer a technological improvement at all. It might still just be a high level of generality. So it really, I don't think it's a necessarily a bad claim in itself. It's one that I think you can accomplish without using that format. You can accomplish incorporation of some aspect of the technological improvement in the claim to render it patent eligible. But nevertheless, I don't think there's anything wrong with using that claim structure. It's just that you have to be mindful of the same the same ways that we would want to measure whether or not the claim is patent eligible or not, even if you use that style. Style is not a guarantee for rendering it eligible.
Right, right. And going back to the Uniloc LG case we talked about earlier, the Federal Circuit tells us that we don't need to include the problem and the solution in the claim. We don't need to say what the solution is and how the problem is. We don't need to say that the problem is being solved explicitly in the claim. As long as we have enough of how the invention is working to solve the problem, we don't need to identify the problem and say, and therefore we're solving the problem in the claim itself. So in view of the fact we don't need to do that, my inclination is less is more in a claim in terms of scope, unless you need to address a one-on-one issue. So I think I would err on the side of not including explicit language like that.
So do you want to? I think what we can probably do is, since we've got a number of new questions, and I know Elliot and I would really love to and enjoy answering them for the rest of the morning, which would be good. I think what we could do is take the questions that we have here, and we'll follow up with the asker after the webinar is over, so we don't keep everyone locked up today. Okay, so in that case, what I will do is basically thank you, of course. You guys have been wonderful, and I think that I want to thank, of course, everybody as well for attending. And I know that, I mean, you gave really practical tips, and I think that everybody enjoyed that, and there was a lot of nice and good takeaways from the presentation. We always get the question, and people always want to know whether they can get the presentation. So I am telling you now, right in front of you, you see Darren's email. It's also in the site that you can just press Finnegan and put down Darren, and you have Elliot's details there. You can ask them directly for the presentations. A lot of people will end up, of course, sending it to me anyway. We will send you their emails, and they will send you the presentations. And I know that it will be very helpful for people going forward. I'd like to also tell you that we will be taking a break in August from the webinars, but on September 2nd, we are returning with a presentation from Gershon Panich, also from Finnegan, and he's also a partner at Finnegan, and he will speak, and he will be speaking to the people who are the in-house IP managers. It is exclusively for in-house IP managers, and he's talking on superpowering your patents by switching from technical to conceptual claiming. I think that's exactly the opposite of what you guys were talking about right now. I'm not going to get into it, but he's talking about conceptual claiming as opposed to the technical claiming. On September 9th, we look forward to another webinar on big data and AI, and that will be open to all. And everybody, of course, will receive emails. I'm sorry if you're getting a little bit inundated by the emails, but it's the way that we can keep you up to date on everything that is happening. And of course, again, if you have any questions, then you can be in touch directly with Elliot and Darren, who I want to thank again, and to Finnegan's support, all their IT support and everything, and apologize because there seems to have been a
a problem with the link. And I apologize to the participants because that's usually, it usually doesn't happen. And I'm sorry that there was some kind of problem with the link, and we'll make sure that it is solved by the September 2nd webinar. So that's it. So I want to thank everybody, unless you guys have anything else you want to add.
Nope. Thank you very much, Kim. As always, like we said before, you do great programming in Israel and do a great service for the IP community. And we are honored to be a part of the programming and work with you. And thank you very much for helping us put this on today.
Well, you guys are always super, and it's great to work with you.
All right.
Keep
Thanks,
safe,
everyone.
keep healthy, and thanks everybody for participating.